Hi, I'm Brian Brown, and this is my series on structural racism in America for the East Hampton Public Schools. Today we're going to talk about plea bargaining, and we're going to talk about the part of the criminal justice system that has to do with prosecution and sentencing. So, the last lecture talked about discretion as far as police officers go, and we talked about the erosion of the Fourth Amendment and the protections against search and seizure by things such as Terry versus Ohio, Wren versus the United States, and a million other cases and laws as they were passed. We didn't talk about those million, by the way. Like with everything, this is really just an introductory course, so hopefully it points you in a direction. If you're looking to find out more information, I highly recommend you go find it. So, today I want to talk about prosecutors, juries, things like that. So, one of the important things to understand about the criminal justice system is that because we have such an active criminal justice system in the United States, there are a lot of people being arrested all the time. And because we have such great protections in our Constitution, which changed the world, our Constitution changed the world, and countries have adopted, so many countries have adopted similar practices and procedures based on what we did. And so we have a lot of protections, especially in the Bill of Rights, those first 10 amendments. So, the Fifth, Sixth Amendment. These give us a lot of protections as far as our rights in court, and there are other Supreme Court cases as well. Right? So we have a right to a trial by jury. We have the right to see evidence against us, to question witnesses against us, to produce our own witnesses, whether they want to be our witnesses or not. A lot of important protections. We don't have to testify against ourselves, so on and so forth. All right? But because we have all these protections, and because so many people are arrested in America, our court system can't actually afford to have trials for everybody. Most cases in the American criminal justice system do not go to trial. And it's important that you know that. So your protections under the Constitution only protect you if you go to trial. But if we were to try all the cases that are brought against people, the system would grind to a halt. All right, you have a right to a speedy and public trial in the Sixth Amendment. These trials could not be speedy if everyone went to trial. And so for the criminal, or we would have to spend a lot more money on courts and stuff like that. We would have to hire a lot more judges and have a lot more courthouses and attorneys and so on and so forth. So, a big thing to understand is that most of the people who are in supervision of the criminal justice system never had a trial. They didn't have a trial with a jury of their peers, with the ability to confront witnesses and evidence against them, and all of those protections that we have. They didn't go to trial at all. All right? How can that be? How can it be that so many people waive their most basic, important constitutional protections? All right. Well, first of all, a lot of people don't know that. All right, which is why we're trying to teach more civics in school and stuff like that, so that people know what your protections and your rights are. Okay. Attorneys don't really have to tell you that. Attorneys are so overworked. Public defenders are so overworked. They don't have a lot of time to explain that to you. They maybe haven't even met you before they're standing next to you in court. Just so you know, the Supreme Court case that provides for an attorney if you can't afford one is Gideon versus Wainwright. So that's the Supreme Court case that says that if I've been charged with a crime and I can't afford an attorney, the state will have to provide me with one. That's a huge expense that the state has to put out, but it's that important to people that I get to have a fair trial. And I'm not an expert on the law. I need an attorney to help me with that. Okay? So anyway, that's where that comes from, Gideon versus Wainwright. Why do people waive these rights that are these huge constitutional protections? Well, here's why. All right, we have a system in the United States called plea bargaining. And the idea is that I can avoid a trial entirely. All right, if I plead guilty, maybe to a lesser crime. Okay, so let's say that I've been accused of stealing a car. A car costs a lot of money. That's going to be a felony, larceny of a vehicle. I could be looking at some serious time. I don't know what the penalty is for it in Massachusetts, but let's say I'm accused of boosting a car, and I've taken it, and I plan to sell it. Right? There's a lot of elements to stealing a car, so that would be a very serious felony crime. Because we don't want all of our cases going to trial, the prosecutor, the attorney whose job it is to prove on behalf of the state that I've committed this crime, the prosecutor may offer me a deal. They may say, okay, you can avoid going to trial, all right? If you go to trial, you might do 5 years in prison for the car that you stole. It's a nice car, all right? But if you plead guilty to stealing a car that you were going to abandon, you're like joyriding it, okay? That's a less serious crime. And maybe I'll offer you 18 months of probation. Okay, so you can either go to trial, in which you might be found not guilty, or you might be found guilty and go to prison for 5 years. Okay, so that's one option that you have. The other option is you can plead guilty to a lesser charge, and you won't have to go to prison at all. All right, and so it's like, well, here's the risky thing I can do that might, maybe I'm innocent, but I would hate to go to prison for 5 years for a crime I didn't commit, right? So I'm taking a risk. Over here, I might be offered a deal where I plead guilty to a lesser crime. I don't do any prison. I just have to stay out of trouble for a year and a half. All right? So that other option where I definitely don't go to prison, I've got to consider that. I might take that deal. All right? I'm on probation for a year and a half. I got to check in with my PO and I got to have a job. I already have a job. I got to make sure that I'm not hanging out with felons. I'm not hanging out with felons. It's fine, right? That's how it goes down a lot. But here's the problem, all right? If the plea deal that I made, that's called a plea bargain, I have admitted that I'm guilty of a crime. And so I now have a criminal record for having broken the law. If that crime is a felony, I may not know it, but I may have just given up my right to vote. I may have just given up my right to serve on a jury. I've most certainly given up my right to get certain forms of public assistance if I need it, if I fall on hard times. And I might have given up my right to possess a firearm, and a lot of sort of rights and privileges of society I may have now given up. All right? Why? Because I didn't want to risk going to prison for a crime that maybe I didn't commit. All right? And so that in itself is enough to concern us. It should be a lot to concern us. Okay? Because the Constitution is there. It was set up by people who wanted to protect us from tyranny. All right? They wanted to protect us from a tyrannical government. And if we are put in a position where we are pressured to give up our constitutional rights, because, man, that's, if I was looking at like 5 years or innocent versus, 18 months of probation and I gotta say, I'm not a gambling man. I'd be pretty tempted by that plea. But what I don't realize is that I am forfeiting my constitutional rights. Okay? And when you have a system that only works when the majority of the people who are in it are giving up their constitutional rights, you have a problem. Okay? Our system would grind to a halt. It would stop working if the majority of people didn't waive their constitutional rights and plea bargain. Okay? That should concern us enough. All right? We're talking about structural racism here. All right? And so we've already, I've already given you the foundation for you to go do the groundwork if you want, do some research, and just see just how biased that first stage of the introduction, how heavily people of color are even brought into the system. So you're just looking at your population that you have coming in. All right. So disproportionately, people who are coming into courts and so on and so forth are weighted heavily towards people of color due to bias and the discretion that police officers are given. All right. As it turns out, the way that this system works as well, people of color are also, end up with a raw deal on the prosecution and the plea bargain side as well. So a quick word about the public defender thing again. Because public defenders have to be provided by the government, but because the government doesn't want to spend as much money as it could on public defenders, they're overworked. They don't have enough time to really build a strong case for somebody who is standing before the court. And so it's been shown in a lot of studies and a lot of articles and research that's been done, some very recent, you don't have to go back that far, to see that there is very little education that's given to people about what they are giving up when they plead guilty, especially to a felony. All right, and that could be somebody who could be totally innocent. I have not stolen any cars. I have stolen 0 cars in my life. All right, I just set up a situation where I've been accused of stealing a car. I've never stolen one. All right, but I'm telling you that I would think about that plea. I would think about saying, okay, yeah, I stole a car. All right, don't make me go to prison. I don't want to risk going to prison. So that's plea bargaining. Okay. The power to offer a plea and what is offered in that plea is entirely upon district attorneys, on prosecutors. Okay? And so what they have found is that the deals that are offered to people of color are less good deals than deals that are offered to white people. All right. And again, is that conscious bias? Is it unconscious bias? All right. Well, in some cases it's one. In all cases it's unconscious. All right. But the reality is that the result is that the deals that are offered to people of color are harder deals, or sometimes no deal is offered at all. Okay. But what they have found is that plea bargaining has led to a lot of people pleading guilty to felonies, and maybe they don't go to prison, maybe they don't see any time. It seems like a good deal, but what has not been explained to them, or even if it is explained to them, all right, I would think if I was looking at 5 years of prison, I would think pretty heavily about like, how much do I care about my right to vote? All right, I personally care a lot about my right to vote. I would still think about that. All right, 5 years is a long time to be in prison. So there's that. All right. If we do go to trial, all right, cases that do go to trial, I have the right to a trial of a jury by my peers. Now, during the Jim Crow era, all right, a lot of black people were not allowed to serve on juries. And so a black person who was trying to get tried by a jury of their peers would have had a pretty impossible time to do that during Jim Crow. juries are still very problematically, misproportionally white. Can a white person understand a black person, or are all white people going to be judgmental or biased against black people? All right, well, of course we can understand each other, white people and black people, and we might be very fair, and there are plenty of people who misunderstand each other of the same race, okay? But the idea of really having representation in a jury is important. And when you see people who are actively trying to limit representation in a jury, that should tell you something, okay? We have what's called an adversarial system in our criminal justice system. It's different than systems in Europe and systems in other places, which are called an inquisitional system, which I know sounds like the Spanish Inquisition, but it's not. But we have an adversarial system. It's not about arriving at truth. It's about who can win the case. Okay, and so prosecutors are trying to win, defense attorneys are trying to win, and the idea is that whoever wins, whoever makes the better case, that's going to decide the fate of the person, of the defendant. So, juries, all right? It is helpful to have a jury of people who understand you if you are standing before a jury. And if people are actively trying to keep people who might be sympathetic to you, people who look like you, off of a jury, that's a problem. That's a problem for you, it's a problem for society, because again, the Constitution was written, it was a revolutionary document that changed the world, and it was written to try to prevent tyranny. All right? If people in power, if the group in power is trying to rig a system, all right, if they're trying to win, all right, against people who are not in power, all right, that's tyranny. Okay? If they're able to rig the system. So, first of all, many jury pools are, people complain about getting called for jury duty, and we got to stop that. Okay, we have to stop that. All right, it stinks getting called for jury, especially if you sit around and you don't even do anything. All right, I'm sure it would be horrible to get dragged into a case where you're like sequestered and you can't talk to people for like a month. That sounds awful, right? I get it. All right, but we have to chill on complaining about jury duty, because the deal is that we need good people serving on juries. And so jury pools are selected sometimes from the Department of Motor Vehicles lists and so on and so forth, so people who have a driver's license. Now, because there tends to be concentrations of people of color who live in cities, if you live in a city, it might be hard to park a car, you might not need a car, so on and so forth. You might not have a driver's license, all right? I have plenty of friends who grew up in cities who didn't get their driver's license until they were in their 20s or 30s, whether they're, white or people of color. Like, you probably have some experience where you know some people like that too. Like, why would I have a driver's license? I don't need a car. It would be stupid to have a car living in Boston or New York, et cetera, et cetera. So if you're just getting your jury rolls from people who have a driver's license, that is actually statistically across the country, it's going to eliminate, all right, a higher percentage of people of color, just because, again, there tends to be concentrations of people of color who live in urban areas. Anyway, so aside from that, all right, and so let's put that aside for now, all right. Let's look at the jury population that we have. Now, because it's an adversarial system, the way that a jury selection works is like this. There's a prosecutor. That's the person who's working for the government. They're trying to show that that the defendant committed a crime. The burden is on them to prove it. And then there's the defense, and the defense is defending the defendant, the person who's accused. So there's a process by which the jury is selected. So you have, 30 people, and you're looking to choose a jury of 12, 9, 7, whatever the number is. So both attorneys have the ability to remove people from the pool. You don't select a jury by saying, I want this guy on my jury, all right? You select a jury by saying, I don't want that person on the jury. And what you're left with is your jury, all right? If I made that clear, right? You don't choose people to be on a jury. You choose all the people who aren't on a jury. What's left is your jury, okay? And so there are two ways that a jury is selected, all right? The first is what's called removal for cause. So if I'm sitting in a jury pool and the person who has been charged with a crime is my cousin, all right, then people might be like, you know, do you know, are you related to the defendant in the case? And I'll be like, that's my cousin. And they're like, well, you can't be impartial, that's your cousin, all right? So you got to be off the jury. So a removal for cause is when somebody's removed from a jury for a reason of bias, all right? They're just very clearly like, that's a person that can't sit on that jury. And so removal for cause, you know, as an attorney, you know, the attorney might say, in that case, probably the prosecutor would say, hey, this guy is the cousin of the defendant, I'm gonna remove him. And the judge will be like, yeah, that makes sense. Get this guy out of here. Okay, so removal for cause, like you really have to explicitly tell the judge, hey, you know, this is why we're getting rid of this guy. The judge has to approve it. There can certainly be bias there, but it's a lot harder. But there's a second way that you remove people from a jury, and this is called a peremptory challenge. And a peremptory challenge, you don't right off the bat have to say why you're removing somebody. Okay? So each attorney gets to remove a certain number of people from a jury pool just by naming them. They say, okay, that guy, juror 13. Brown, get out of there. All right? Now, that's how a jury is selected. Remove for cause, peremptory challenge. And so, you know, there were a lot of people of color who were being removed from juries, and so there have been a lot of legal challenges to the peremptory challenge. And basically what the courts have come up with is that the only time that a prosecutor or an attorney in general can get in trouble for removing somebody based on racial bias in a peremptory challenge is specifically if it's the only reason. You basically have to articulate, like, that person is black, I don't want a black person on my jury, all right, that's why I remove them. You only have to say, it can even be a part of why you remove them from the jury, you just have to give like one more reason. And the reasons that people give are ridiculous. I talked briefly, I didn't even talk about it, I just told you to go look it up, and I'll do the same here. This is kind of like the drug courier profile list. It's like you can come up with any reason to say that you're taking somebody off of a jury. You just have to, the only reason can't be because of somebody's race. Okay? And so what we have is a situation where most cases don't go to trial at all. And so people are waiving all their rights as far as their protections to a fair trial. And protections as far as their sentencing and punishment go, if you want to look at the Eighth Amendment, so on and so forth. When cases do go to trial, the rights of the Sixth Amendment that have to do with the jury and so on and so forth, those are also pretty heavily eroded by the process that we have. All right? And so we end up having people be convicted, people being sentenced. Sentencing is another whole topic that, again, I get you to check it out. You want to look at differences in sentencing as far as, differences as far as black and white. Look at sentencing. Look at the death penalty. Look at who gets the death penalty versus who doesn't. As far as sentencing goes along racial lines, it's shocking. Or people who are charged with crimes that could result in the death penalty. It's staggering. It's undeniable, really, proportionally. And remember too, whenever you're looking at statistics in America about white people versus people of color and how they're treated. Remember that black people in America make up about 12%, 11 to 13% of the U.S. population pretty consistently throughout history. White people a much higher percentage of that population. And so remember that if you're like just comparing numbers and stuff like that, remember that you know that's almost a 10 to 1. It's not almost a 10 to 1, but you know probably like 8 or 7. So statistically speaking, if the numbers are close, that means that a much higher percentage per capita, per person, of black people are being, you know, charged, sentenced, whatever statistics you're looking at. Just sort of keep that in mind. Okay, so the big idea, not to lose the big idea, is we're looking at structural racism, we're looking at the criminal justice system, and in this case, we're looking at when people actually go to court. And what we see is that from the last lecture, we have many more people of color who are being brought into court in the first place, evidence that has been seized in some cases due to an erosion of the strength of the Fourth Amendment, protection of unreasonable search and seizure. And now we're looking at courts and we're seeing, again, these ways that bias can creep into a situation of plea bargaining where, again, like most people waive their constitutional rights in this case, and basically all the power is put in the prosecutor's hands. All right, you know, in the 90s, I don't know that I talked about this nearly enough. In the 90s, there was this idea of like get tough on crime, and we need like law and order. That really was messaged very strongly by President Reagan, and President Clinton wanted to show that he was a tough guy too. That Democrats weren't soft on crime and stuff like that. And so, and of course there were Republicans who were pushing for things like mandatory minimums. There was basically this idea that was floated that that judges are liberals, that they're letting people off too easily. We see the infamous Willie Horton ad that sunk, you know, Mike Dukakis's attempts at becoming president, and so on and so forth. There's this idea that judges are way too soft on criminals, and we have to take the power away from the judges, and we have to put it. We have to say, judges, you can't give people light sentencing anymore. All right. Discretion was taken away from judges by legislators, so a different branch of government, or by the executive, and all of that discretion that the judges used to have is now put in the hands of the prosecutor. Okay, so think about that. So a judge is supposed to be a neutral party. In an adversarial system, all right, you have the judge in the middle. And you have, on these two sides, you have the prosecution and the defense, which are both trying to argue their case. Okay? And so the idea is that justice is neutral, it's in the middle, and there's a judge who has discretion to make a choice. And you have these two sides that are arguing it out. All right? And what we've done is we've taken the power, the discretion away from that neutral party, that middle person, all right? And we've given it to one of the sides, the prosecution. All right? So that discretion, who gets charged at all? All right? What kind of deal are you going to offer somebody? Is it going to be a felony or is it going to be a misdemeanor? Are you going to offer them a deal at all? That's all in the hands of the prosecution in an adversarial system. All right? Politicians decided they didn't trust the guy in the middle. They're giving the power to the person who is trying to win. And in this case, that takes the power away from the person who's trying to defend the citizen, the American, right? Not the citizen, the American. All right? The Constitution doesn't say we the citizens of the United States. It says we the people. All right? If you're in the United States, you're an American. And those protections are for you. All right? And so the shift has gone from the neutral party to the state, all right? And that is the kind of tyranny that the framers were worried about. I think we should be worried about it too. This is an incomplete look at the criminal justice system, all right? The next lecture is going to be the last one. I'm going to talk a little bit about the history of the Black Lives Matter movement. what it means, why it's not a radical idea at all, why it's not a political idea at all. It's just simply an idea that people should be considered who are not being considered. All right? But anyway, it's an incomplete look at the criminal justice system, but it's something to talk about. It's something to research further. As always, if you have questions, please ask them, put them in the comments. I would love to be able to respond to them. Okay? Thanks for tuning in. Have a great day.